Davis, Harless, Burkett, Israel, Patty, Murr.
Quorum is present. The chair now lays out House Bill 3265, and the chair will explain the bill. Also, there is a committee substitute, so the chair offers up committee substitute to HB 3265, and Chairman Guillen is in another hearing, so he asked me to lay his bill out, and I'm just going to read what he's written for me here. It's HB 3265 is a towing and storage deregulation bill. In 2007, the regulatory authority of the towing and storage industry was shifted from the Texas Department of Transportation to the Texas Department of License Administration, so from TxDOT to TDLR, I believe. The regulation framework remained the same, but was burdensome to the industry. Several sessions later, the legislature passed measures to further regulate the towing and storage industry. Over the past year, TDLR staff has reached out to the towing and storage stakeholders and business owners, asking for feedback on how to take the business practices out of the code, as well as simplify and streamline the regulations. House Bill 3265 seeks to promote public safety through comprehensive safety requirements, while also reducing regulatory burdens on small business owners. The substitute includes additional deregulation, which includes, but not limited to, reducing the number of licenses by eliminating or combining them, eliminating duplicate random drug testing for CDL holders, changing operator reimbursement language to reflect amounts actually paid by the consumer rather than the assessed value, updating inspection sticker language to align with the state's single sticker requirements, requiring conspicuous notice or window stickers for warning so that drivers are forced to acknowledge them, reducing tow sign requirements to allow for flexible standards. 99% of the current signs are out of regulation, as well as clean up statutes to eliminate superfluous repetition, lifting restrictions on things of value exchanged between knowledge that Representative Burkett is here. Glad to have you here. It's okay. Just getting started. I'm into the towing bill right now, so just cleaning up all duplicate language regarding notice by publication, allowing vehicle storage facilities to employ notaries and charge for notary services for customer convenience. We have a few witnesses, including TDLR as a resource, and I will reserve the right to close. Our first witness, chair calls Ken Ulmer. Is Ken here? All right, Ken didn't stay around. Sorry for us having to come back this afternoon. Chair calls Jeanette Rash. Jeanette didn't stay around either. Sorry. Chair calls Donald McClure. Donald didn't stay around. Chair calls Juan Messina. All right. Joanne Messina. Sorry. Okay. We'll just show them as not testifying, but their position on the bill. Chair calls David Mintz. David, if you just state your name and who you're with and your position on the bill.
Good evening. My name is David Mintz. I'm the Vice President of Government Affairs for the Texas Apartment Association. I'm here this evening in support of the legislation. I want to really talk about one particular issue within the bill that my understanding it's not in the committee substitute that's been presented to the committee, but I hope that it'll be reflected in future versions of the bill.
Okay, so this is not in the committee substitute as it stands, but you would like to see it.
That's correct.
In an amendment or a future version
yes.
of the bill. Okay.
Recently, we became aware of an interpretation by the Texas Department of Licensing and Regulation that if a property owner is doing work on their property that involves having to move vehicles, so a restriping of a lot or repaving or fixing of potholes or something else on that property, and there's a need to move vehicles, that if a towing company comes to do that, they have to take the vehicles to a vehicle storage facility rather than moving them somewhere else on the property. We look at that as a difficult thing for both the consumer, who has to worry about having their vehicle towed off someplace, and for the rental property owner as well, or the property owner. It could be an apartment, it could be an office building, or some other type of facility. The original filed bill had a provision that allowed vehicles to be moved within the property itself to another location, and we'd like to see something along the lines of that remain in the legislation. We do think it's important that we be able to recover costs for that. If the towing company is charging us to come out to the property to move a vehicle, that we be able to pass that cost in of itself along. It's not anything that we're looking to have a profit center or any kind of margin on. We just want to be able to recover that cost, because otherwise it has to be absorbed somewhere else within our operating expenses. And I can tell you that it's very common to have notice several times to residents that work is going to be occurring before the actual work is done, so that you can clear the property as much as possible.
But there are some situations that they just don't respond and you have to tow those vehicles?
Yes, exactly. Okay. And that's what we're trying to help make sure it gets addressed.
Okay. I think Representative Israel has a question as soon as she can find the fancy button on this table. There we go. It's on. Yeah, there you go.
Yeah. Thank you, Mr. Chairman. Mr. Mintz, I was just wondering if you had a chance to visit with Representative Guillen about your concerns, and do you think there's an opportunity to include those? Because I think you raised some valid points.
Yes, my understanding is they're very open to working with us on that. We've talked to the department. We've talked to the two towing associations as well. I don't know of any opposition to the concept. I think it just got left out of the committee sub. I don't even know that it was a conscious thing.
Thank you.
Members, any other questions? Thank you, Mr. Mintz.
Thank you.
That. All right. The chair calls Paul Martin. We will show Mr. Martin as choosing to testify, but not choosing to testify, but registering position on the bill. The chair calls Warren Norad. Mr. Norad, if you'll just state your name and who you represent and your position on this bill, please.
My name is Warren Norad. I put my name down as neutral, but the reality is that I have a lot of negatives about the bill, and I have a few positive sentences about the bill.
Do you want us to change it to against, or you want to leave it as neutral?
I think basically against is probably going to capture the spirit.
So have your permission to change your position to against the bill?
Yes, you do.
Okay.
Thank you.
We'll do that, yeah. Go ahead.
I left some documents, which I think that you've had distributed, and I thank you for that. I noticed in the remarks as you were introducing, say again?
The microphone closer to you.
Is the microphone on?
Is that better?
Yeah.
There you go. Okay, I noted in the remarks as you were introducing the bill that there was a suggestion that a lot of the stakeholders had input. I've had the opportunity to walk around all day, because we didn't get to it this morning, and talk to a number of the committee members. And what I found is that it doesn't seem to be that there's been a lot of stakeholding input from the class of people who are the targets of predatory towing. My firm, Norad Law, does a lot of work in bankruptcy, intellectual property, and litigation. But when we first started, as every lawyer does, a lot with whoever comes in. And so we did a lot of work in tow law, and we still are the #1 probably law firm in North Texas to handling illegal tows. Since we first started, we've continued to have the same recurring problems, and it's getting worse. We have people that are coming in and they can't get redress for when they're illegally towed. In 2011, you had a change in the law that took away attorney's fees from the civil suit. So a tow company can come in and they can tow a lot of people in one day. They can make a lot of money. And somebody who's illegally towed can come in and sue them, take a year to 2 years to win, and the maximum we can win is $2,000, which I've got to split with my poor client who couldn't afford to get his car out of hock, who could barely afford to do that.
Will the person's car be impounded during that entire time, or will they get their car back?
We tell people to go get their car back immediately.
So they have to pay to get it back?
Right.
Okay.
So they pay to get their money back, and then they've got to pay us something just so I know that they've got skin in the game, otherwise they tend not to do well. So they're $600 or more into it, in a possibility of winning maybe $2,000 in a year or 2 years. During that time, opposing counsel will bring up things like the Motor Carrier Act. And this is I would have thought that you guys knew about this, but 11 USC 49, the Motor Carrier Act, is considered to be, by some people, to be a federal preemption of all of this regulation on tow laws. And there's federal statutory case law on this, and it's an ongoing fight that we have with the tow companies who will walk in and say the Motor Carrier Act, which is designed to level the playing field in motorized trucking, deregulated also and made it freed up state law, and it doesn't have any impact on them because it impacts the price, towing, or route of a tow company. We think that's absurd, but it's not an argument that can easily be laughed out of court. You have to come meet it with a lot of work. And so it would be helpful if a law had something to the idea that according to that no Texas court, no Texas state court shall recognize the Motor Carrier Act as preempting our local and state towing laws. There are a number of other things that you could do. I think the violation of the Act, and when I say the Act, I mean the Texas Towing and Booting Act, would constitute a deceptive trade practice under the statute, the Texas DCPA. That would bring into the actual practice of enforcing these issues a lot of case law from DTPA. Be very helpful. Right now, you've got a lot of things in the law that are vague. I've given you a handout of things that I think are particularly heinous. Some of these may or may not be in the substitute that I don't have. Among them was the elimination of 401 and 402. Currently, it's against the law for a tow company to give something of value to an apartment complex to get their business. If you allow that, which is what this bill does, I don't know if it's in the new substitute. What you're doing is you're asking for corruption. The apartment manager gets a car for her child, and then she gives the tow company who's breaking the law currently the business. And that tow company starts to look at things. Well, your car's tires are a little bit low, so we're going to tow your car for being abandoned. This happens in Section 8 housing and in low student housing all the time. And these people come in and they can't. I can't help them because they don't have any money, and I do have to put food on my table too. So there are a number of things on this bill. I could talk for a long time and regale you with war stories about bad things that have been done. But there are other people that need to talk. But okay. I would generally say this is a bad idea. I'm happy to answer any questions you have.
Okay. Have you spoken with Chairman Guillen on this bill?
I have not.
Would you mind trying to get in touch with him?
We just didn't have enough time.
It's okay.
One of the things that I wanted to do today is make sure that you guys knew that we existed, right, and that we would love to have some input into this.
Thank you. And
there's some things in this bill. It's not totally heinous. There's the subchapter language. I don't know if you're familiar with that, but you brought this information. The Texas Towing and Booting Act is old Transportation Code 683 moved over. Well, there's places where it says chapter and it should say subchapter
right.
now.
Some of it's just
cleanup. Okay. And so, okay. but the tow companies.
Members, any questions?
Grab that.
Thank you for being here. The chair calls Chad Lampy. Thank you, Chad. If you would just state your name and who you represent, your position on the bill. And I know we've had some other people walk in that may have registered to witness earlier. If you have registered to testify, then we will get to you. We may have already called your name, but I'll come back to you. If you haven't yet registered to testify, please do so in the kiosk outside. And we are trying to keep our testimony efficient.
Thank you. My name is Chad Lampy. I am. I was neutral on the bill. I would move, if you can move me to against okay. After conversations today.
We will move you to against, Mr. Lampy.
Thank you. I work with Mr. Norred. I'm an attorney. We represent tow victims, and what we give you a handout on the first page, page 1. There's 4 things. If I could wave a magic wand to make the towing law better, these are the areas that I would change. Again, I don't know how these are reflected in the current bill that's been proposed. I think that subchapter 1 is important. Right now, there are tow companies making arguments that if you want to sue a tow company, you have to bring it in JP court. Well, there's a problem. What happens when the tow company damages your vehicle and it's more than $10,000? But the fact of the matter is we're having to fight these day in, day out. And as Mr. Morad spoke about, the attorney's fees issue is a big thing. There is no stick big enough to fight the tow company. If a person has been towed, they're out there $300. A lot of times the tow company is the one providing the parking permits for these apartment complexes. If you have a bad month, you have a medical bill, you get behind on your rent, then you can't get your sticker. You can't get your next month's tag, so you get your car towed. So it's a snowball. You end up getting evicted, you end up losing your car. And you can't go to the attorney's office, you can't walk into the attorney's office and he looks at your case and says, okay, yes, there was a violation of the tow statute. However, there's no, you can't recover attorney's fees. So, and you're going to pay me $200 to $300 an hour to fight this case, pay me $8,000 over the course of 2 years, and can the average person do that? No. Is the average person going to put $8,000 to get $2,000 back in justice? No, they're not. A big change would be to put the way the law was back in 2308, 404, to put the prevailing party provision back where attorney's fees are awarded to a prevailing party. Yeah, it's a stick against bringing bad lawsuits, because you're not going to bring a bad lawsuit and stand getting the tow company's $10,000 judgment against you. But it puts more skin in the game. If a tow company can tow 200 vehicles a night, averaging $165 to $300, in one night they're making $50,000. Well, if you go to and your stick is, I'm going to sue you for $2,000, and you're going to pay that 2 years, why would you not stop? Why would you not? There's nothing to prevent you from keeping breaking the law. It's profitable. The other few things on here, there's some minor variations. These are just often litigated things. There's questions of what is a minor variation under law. The tow statute as it currently has requirements for the lettering, the height. Well, the question is there's like a 2-inch requirement on it, says towing enforced has to be 2 inches. Well, what if it's 1 inch? Is 50% a minor variation? And we've litigated these things, and those questions are in the Court of Appeals in Fort Worth right now. This is all kinds of stuff that needs to be cleared up to make this, to make it more efficient. Exact language. There are requirements for what language needs to be on a tow sign. I think there was talk about making these more flexible. I think right now there is quoted language in 301B5 that's in quotes. So the argument that we make is that the legislature intended that on the sign it has to be the specific words. But tow companies are saying, well, it's close enough. So the standard is, and the thing is, the tow companies, they will tow for technicalities. Well, they need to be held to the technical standard of the law. If they're going to tow for having your tire an inch on the line, then they need to be held to the technical standard of making sure that their signs are technically compliant with the statute. The argument, there's the penal code, which has the concealed handgun language, and I think it's well stated in that section. It says on penal code 30.6 CA, which is written language identical to the following, and it has the language. So having some kind of clarification of what the tow company, so they don't have to divinate. They don't have to decide, is this good notice, or is it, are we complying with the law or are we not? Because these are what often gets litigated. And so clarification on that, the attorney's fees, and cleaning up the law. Those are things that, as this moves forward, and as if these things don't get accomplished this year, that we will hope that I know the tow companies get down here a lot and they get their say a lot, but the people that are getting towed don't get their say, and so that's what we hope you'd hear.
Absolutely. And my recommendation is, as we're getting down to crunch time here, so really the parties need to come together and figure something out with Chairman Gee and whether or not we can get something done that's good for the industry this time. But thank you for being here. I really appreciate it. Members, any questions? Thank you very much for being here.
Or, like I said, to deal with the training, we'd like to even get Texas A&M TEAC and the University of Junk Vehicles. So that
present in your position on the bill. And again, I would just ask people, please, we do want your testimony. Just try not to be repetitive.
Good afternoon or evening, guys. My name is Don McClure with Texas Auto Title. I am against the bill at this time. As you said, I will not repeat a lot of it. Some of the issues I have is I do quite a bit of auctions for law enforcement under Transportation Code 683. Record Service are required to report notice of abandonment to a law enforcement agency. Many of these agencies do not take custody and dispose of these vehicles, but quite a few agencies do. I have also been in these meetings this afternoon. We are working on a substitute for that, and that's pretty much all I got.
Thank you very much for being here. Members, any questions? Thank you for being here today. I really appreciate it. Joanne Messina, Chair calls Joanne Messina. Ms. Messina, if you just state your name, who you represent, and your position on this bill before testifying, please.
Thank you, Chairman Simmons and committee. My name is Joanne Messina. I'm Legislative Chair for Southwest Tow Operators. We represent about 500 towing and storage companies in the state of Texas. We worked with Representative Guillen on this bill. We got the sub late last night, and we've been in meetings this afternoon to try to iron out some issues with the other stakeholders.
Did you say you were for the bill?
I am in favor of the bill, yes, sir.
Thank you very much.
As Jeanette said, the statutes are very complicated, and for tow operators are very intelligent, but they're not lawyers to read the rules. So what we do each session is try to simplify some of the language and resolve some of our issues that come from the statute, and that's what we're doing with this substitute. Donald mentioned law enforcement reporting. That's a huge issue that we're trying to address in this substitute. And the language we have in there isn't quite what we want. We're looking at substituting that language to satisfy the other stakeholders and to correct the issues. Currently, we're required to report to law enforcement and pay them $10 a vehicle, whether they want it or not. Most of the law enforcement agencies they don't have time for this. They don't want to see our abandoned vehicles, and they don't want the fees. Yet we're required by law to do it. So if we don't do it, we're fined by TDLR. So we've got to resolve that issue. Another issue we're trying to resolve is the notary fee issue. Right now, if I wanted to go pick up my sister's car from a vehicle storage facility, I have to have a notarized form in order to do that if she's incapacitated. Well, the VSF has to provide that form, but they're not allowed to provide a notary service for it. So the consumer has to leave the vehicle storage facility with the form and go find a notary.
Which makes no sense.
It's crazy. So we want to fix that issue in this bill. So there's several little ticky-tacky things, and we met with TDLR this afternoon and TTSA. We're trying to work out our differences so that everybody will support the bill, and we hope you will support it and help us move it forward since we're running out of time, get some of these issues done. But we do want to make it a good bill for the industry.
Thank you.
And the industry is a good, hardworking industry. We're not, I know there's a lot of examples of problems that they brought up, and that happens, but the majority of the people are good, hardworking people, and we want to make it easy for them to comply with the law and not difficult.
Right. Thank you. Members, any questions? Thank you very much for being here.
Thank you for your time.
You bet. Chair calls Paul Martin. Okay, Paul, that's 3 strikes. You're out on Paul. Is there anybody else wishing to testify on, for, or against committee substitute for House Bill 3265? Yes, I'm sorry, Mr. Johnson. Chair calls Pat Johnson.
Yep.
That's you. Yes, sir.
Hard to hear it, sir.
That's okay. I'm doing the best I can.
That's when we take up the hobby of competition car audio. That's where I tell our children, turn that radio down.
If you'll state your name, who you represent, and your position on this bill, please.
Members, my name is Pat Johnson. I'm president of Texas Towing Compliance. We're the statewide tow watchdog, and we run the only 24-hour hotline for vehicle owners, lien holders, and property managers and tow companies to call. Now, this bill that Guillen's got filed, if history follows itself, anybody who supports this bill will not be here in the next session.
Or so you're against the
Last
bill?
session.
Mr. Johnson, are you against the bill?
What?
Were you against the bill? You are against the bill?
I am against the bill. That is correct. We are against the bill. Texas Towing Compliance has 15,000 members and 207,000 subscribers, and everyone in our organization is against this bill. What they're trying to do is they want to remove the word remove and removing out of the wording of the current statute and put the word tow or towing in there. And what that's going to do, it's going to let the feds are going to overturn this law because it'd be preempted. when I brought the legislation to the legislature in 91 to Glenn Maxey, this law was written for parking facilities. If a parking facility want to have a car towed, they want to know what they had to do it legally so they wouldn't get sued. Miss Rash was here, and everyone agreed this was for the parking facilities. Now, unfortunately, it's come to the point where we can't trust TDLR, because TDLR wants to, they've got evidence that corruption exists in the tow program and the vehicle storage program, but instead of revoking these licenses and suspending these licenses for these companies, they're dealing with commissioners that want to cut them breaks and give them $1 fines and put them on payment plans. That's just not fair to the agency. It's not fair to our taxpayers. And it's sure not fair to the people who get victimized by these tow companies daily. Now, the last speaker that was up here, Miss Messina, she sits on the advisory board for TDLR. We talk about the spirit of the law. The law states that anyone who sits on that advisory board must be an owner of a tow company. She does not own a tow company. We have no representation on the advisory board for the companies who obey the law, because all the commissioners, all the advisory board members representing the tow program, every one of them been fined by the state, and now they want to shut Milstead down for taking advantage of a teenage driver over in Conroe. This legislation is bad for Texas. We need to leave the law the way the law is now, leave it the way it is. Because TDLR didn't even tell the tow companies till 10 months after you passed the law that went into effect the last session about the changes in the signs. For 10 months, tow companies towing cars illegally. They ask TDLR what to do, they don't tell them anything. And then they want to tell them, well, you don't have, if you, the law, we fought this tooth and nail in the last session about them giving anything of value. Because if you allow them to give them a fountain pen, they'll buy them a new house, and we're seeing that right now in Austin on their contract rebid. So just remember, Tuffy Hamilton, we voted him out of office because he filed this fiasco that these people are financing. Last session, Jeanette Resch comes up here and praises John Corona of how much good they've done for their industry. We had him voted out in the primary because people getting tired of corporate greed.
Mr. Johnson, please leave your comments directly on this bill.
But do what's right for our citizens.
Mr. Johnson, listen to me. There will be no threatening comments, okay? Thank you for being here. Is there anybody else who wants to testify on, for, or against House Bill 3265? And with not, then the chair calls on the chair to close. And I close. Members, that's our end of the order of business for today. So the chair moves that the subcommittee on long-term transportation infrastructure planning adjourn subject to the call of the chair. Is there objection? The chair hears none. Subcommittee on long-term transportation infrastructure planning is adjourned.